My name is Jasmine Spei. I'm a recovering lawyer. My pronouns are she and her, but we're joined here by a very real lawyer, so don't worry. I do want to acknowledge the fact that Kat and I are doing the workshop today from Tekaronto, which is the traditional territory of the Mississaugas of the New Credit, the Wendat, and the Haudenosaunee. So I'm a recovering lawyer. I am doing the artist rights seminar here for T.R.A.I.N. I've been a freelance consultant for about 5 years now. Previous to that, I worked in policy development, labor relations, and theater and film and TV. In my legal career, I was a real estate and corporate lawyer, but we don't really talk about that too often. In my freelance career, I have done everything from running an art gallery to doing workshops for After Me Too, to helping organizations with their policies and procedures, pretty much anything where I can help out either with my legal brain or my labor relations brain. I'm happy to do so, but my absolutely most favorite thing to do is what I'm doing right now, which is providing education for artists and arts workers around these areas of contracts, negotiations, copyright, trying to do so in a way that makes sense, which is accessible and isn't too full of legalese. All right, having said that, I would like to introduce you to a guest speaker today, which is Kat Lovrics, who is a lawyer here, an intellectual property, an actual real grown-up lawyer here in Toronto, an intellectual property lawyer. And thanks, Kat, and I'll get you to introduce yourself.
So thank you, first of all, for having me, and thank you all for making the time to come. I'm a lawyer and a partner at a firm called Marks & Clark, and I am also on the board of an organization called ALAS, Artists for Legal Advice Services, and Artists and Lawyers for the Advancement of Creativity. I practice in the area of copyright, trademark, as well as some marketing and advertising law. I'm sort of a strict IP vertical, and candidly, in my private practice, I am regularly approached by artists, and my fees are out of reach. So my time with ALAS and the time that when I do things like this, it's intended to ensure access to justice, that information is shared. ALAS does run, I'll do the plug, ALAS does run legal clinics where lawyers volunteer. I'm one of the volunteer lawyers. I'm not only on the board. And there's half-hour sessions where you can sort of, to the extent possible, cover a legal issue with a lawyer. You're not retaining that lawyer, but it is a free service. We take donations if you can do it, but it's a free service. And I'd encourage you to spread the word. We are Ontario based, and if any of you are joining from any other provinces, there are equivalent clinics in most other provinces and territories of Canada, and we can provide you with that information as needed. Do as much as I can in order to facilitate legal services to the creative community in Ontario and globally.
And we're so glad that people like you exist. So thank you again. Let's talk about copyright. Before we do so, because we have a real live lawyer on, we do want to be clear that this is not legal advice from either myself or Kat. This really is for information purposes. You're going to learn so much during this session that you're going to feel like you can go out and teach copyright to like all your peers. Go ahead, but don't use our stuff. So just our little disclaimer. To get started, I kind of tentatively call this my copyright burn book exercise. I know probably everyone in the room has varying degrees of familiarity and knowledge about our current copyright system and legislation in Canada, but I wanted to get everyone a chance to kind of let us know, what does the term copyright mean to you when you hear it? Whether it's what feeling does it elicit, like what is your basic understanding of what it is? If you're familiar, Muriel, you know that you can just double click on one of the post-its, type in, you can click and drag, or put in the white ones there. We just wanted to get a sense how everyone kind of just feels about this topic and about this system by which artists in this country earn a living. Ownership, that's a good one. Protection, also good. Intellectual property, absolutely. Overwhelming, absolutely as well. I like the honesty. I like it. And it is. Legal framework that regulates the use of creative expressions. Clarity. I like that one too. I'm glad someone feels that it's helpful. And it is. Historical protectionism. Yep, that's pretty much the one I was looking for, because that is true. And I think that's a great segue to our little introduction. If you want to scroll down to who came up with this. We're talking the 1700s here, where at first the UK wanted, in the British Statute of Anne, the publishers, once the printing press came into play and they no longer could control copies of they wanted a system whereby they could do that. That shifted a bit in France after the French Revolution. More of something called a natural right was recognized, that the right of ownership should be with the artist, that it was a creation that was born out of the artist's psyche, I guess. And that's what tilted the system more towards the protection of the artist and the artist's right to earn from their creation. So these are just kind of like choice quotes I pulled from a Wikipedia entry just to show that the establishment of the system was rooted very much in the patriarchal society of wanting to preserve money for institutions, whether it's the church or publishers or owner of publishing companies in the UK. Again, in France, it became more about moral rights of the artist itself. And we see this reflected in our current copyright system, which covers both financial and moral rights. But before we get to that, I wanted to throw it over to Kat, just because we're focusing on copyright today, but there is a whole system, as someone mentioned, intellectual property in this country. I throw it to Kat to just give her brief overview of what there is out there besides copyright.
I find that often there's quite a bit of confusion as to what different types of IP protect. And I thought it would be helpful to kick off just to talk about trademarking the copyright for your patent and the difference between all those things. So from a very high level, trademarks are brands. They are the things that identify a particular product or service as being affiliated with or as coming from a particular source. They can be words, they can be designs or logos, they can be slogans. And they arise automatically with once reputation is garnered. But if you don't register your trademarks, you only get them for the spaces where you have that reputation and can prove that you have it. Copyrights protect expression that is fixed, and we'll dig deeper onto that in today's sessions. I'll refrain from diving in. Patents, you must register a patent in order for anything to be protected, but really they protect inventions. They can be structural, functional, or processes, but it's the thing that is invented. Everything from pharmaceuticals to mechanical, or pharmaceutical formulations to mechanical inventions, through to biotechnology stuff, through to tech, through to software. Key there, though, is the patents must be registered, and otherwise the invention must be kept a secret. Industrial designs protect the look and feel, the look of something, and non-functional aesthetic elements. Historically, industrial designs really were the domain of three-dimensional objects. So sculptures, sort of the sculpture, the shape of something, Coca-Cola bottle being one of the quintessential examples of an early industrial design. More recently, industrial designs are actually being used to apply to two-dimensional things. So the look and feel of an interface, when you open a phone, the look and feel of what the layout of the phone, icons and the rest of it, as well as now to animations on the branding side, so bumpers and the like. And then finally, there's confidential information and trade secrets. Confidential information is protected largely by way of agreement and protocol. You don't have to register it, you just have to keep it a secret. But the minute that the secret spills or is broken, you lose the ability to protect the trade secret, and it becomes part of the commons. So often patented inventions, when people can't protect the secret sauce for an invention, they'll try to keep it confidential information and have to put in place protocols and strict by way of agreement and penalties effectively to try to keep things controlled in a secret. So that's sort of the 30,000 foot level on different types of IP.
Awesome. Thanks, Kat. I feel like industrial designs and confidential information are like the lesser known cousins in IP. Everyone kind of knows trademark, copyright, patents as the big three. And then I think it's very interesting to know about those other two things, especially in a room of creatives.
Yeah, the other area that tends to come up is sort of personality or privacy rights, which are sort of two sides of the same coin, where an individual has rights in their likeness or image, which raises both clearance as well as commercial clearance problems, but as well as commercialization opportunities. And we won't dive too deep, but it's sort of the other area of rights that is important to keep in mind.
So copyright is, and this is the definition I took from the Canadian Intellectual Property Office, I'll zoom in a bit, type of intellectual property protection provided to original literary, musical, dramatic, or artistic works through copyright. An author enjoys several rights, including the right to prevent others from reproducing their work or copying any substantial portion of it. Copyright laws also apply to performances, sound recordings, and communication signals. So it's kind of a very broad definition. Copyright itself in the legislation is broken down to two major rights: the financial rights, which is your right to make money off your creation, and the moral rights, which is your right to basically not have your creation sullied or displayed or interpreted or put out in the world in a way that you did not intend it to be used. I want to get paid, I'm giving you the rights to that. Your financial rights can be waived or assign, meaning that you can decide not to make any money off your creation and give it away freely, or you can assign it to someone else to use and to profit from. Your moral rights, you can waive those. You can say that, I'm never going to come back and speak up that I feel like you burning the canvas of the work I just painted, I'm not going to come after you for that. But you can't assign them. You can't assign the morality in your work to another individual or corporation, which I think is quite logical. And the newest thing is that happened in Canadian copyright law is as of the end of last year, the term for these rights are the life of the author plus 70 years. Up to now, it's always been 50 years. So I believe it now mirrors what the US is doing. So the US is still 70. And I know when the US switched to that quite a long time ago, it was called the Disney extension because all of Disney's intellectual property rights were set to expire soon and go into the public domain. And anyways, yeah. And then I will again pass it over to Kat to talk a little bit more about different way your rights, especially your financial rights, can be assigned or licensed in your work.
So I think the first thing to keep in mind in terms of copyright is it arises automatically, and it's really an author's right at first and foremost. So the author of a work, person that expresses the work, not the person that comes up with the idea for it, but the actual person that puts pen to paper, paintbrush to canvas, or whatever else, it is the first owner unless the work is created in the course of employment. If the work is created in the course of employment, the employer, from a Canadian perspective, is the first owner. Different jurisdictions have different rules surrounding how ownership and first ownership works. In the US, they have a work for hire concept, which everyone seems to think is part of Canadian law, but it isn't. In our country, if you are a freelancer or a contractor or not an employee in the strict sense of the word, you are the first owner of copyright. Authors also have moral rights, as Jasmine mentioned, which are the right to be associated or remain anonymous, and so in association with your work, the right to maintain the integrity of the work and all where reasonable. The economic rights are alienable, which is a fancy legal word to say that you can transfer them or sell them or give them away to another party. They're assignable. Moral rights are not. Moral rights can only be waived. You can't sell them. You can't assign them. Only the author and the author's heirs have moral rights. In terms of how you can exploit the copyright side of things, you can exploit them by way of assignment, and that can be a whole or a partial assignment. So all rights, only some rights, all media, only some media. You can slice and dice as you wish, or you can grant a license. And it's very important to understand the difference between an assignment and a license and the different types of assignments. So if there's only a handful of things that you take away from a legal perspective, assignment and license should be one, and the difference between exclusive sole and non-exclusive should be another. Assignment, you are giving away something. What's important to keep in mind there is to know that you are truly giving it away and to think about things like reversion. So if you're, an author of a book, do you get rights back if the book goes out of print? Are there certain things that need to be met along the way in order for that assignment to remain effective? And can rights revert at any point or upon certain triggers? Is there a term to the assignment? Is it perpetual forever? I give away my rights and I wash my hands. Or is it a 1 year with a right to renew? So thinking about giving away rights, what length of time, whether or not you get rights back on certain triggers, and then what rights you're actually giving away. You don't have to give away everything. You can divide up by geography. So for example, if you have somebody that's only interested in the Canadian market, you may not want to assign worldwide rights. You may only want to assign Canadian. So just think strategically about the slice and dice. Licenses are really granting a permission. You're saying to somebody that I own rights in this work and you can use it for A, B, C, D, E, F, G. Again, you can slice and dice. On this front, it's important to keep in mind the difference between exclusive sole and non-exclusive. And a non-exclusive license basically means that you can license anyone and multiple parties all at the same time. A sole license is that you can grant only to one licensee, but the copyright owner may also use the work. So typically though, when a license is being negotiated, the first position of the party trying to secure the license will be that they want an exclusive license. Here, it's a big misnomer, including among the legal community. This is often a point of trip up. An exclusive license excludes the grantor. So if you're the one that's the licensor, you're the party that's granting the license to a third party, and you grant an exclusive license, you're excluding yourself from exploiting the work. The only party that can exploit the rights that are being granted is the licensee, and the licensor is effectively washed their hands. Also at law, there are certain implications that come from an exclusive licensee. They're technically in the position of the owner for the period of time. Usually they can enforce rights, although typically you require the consent of the owner to do that. If you're presented with an exclusive license and you're prepared to agree to only one licensee and you want to retain the right to do whatever it is you're granting permission for somebody else to do, it's a sole license that you should be granting and not an exclusive license. That's a little trick to keep in mind. If you can change the word exclusive to sole, you're at least retaining your own ability to be able to do whatever the rights being granted are.
The biggest example I've come across in terms of licenses and being able to carve off those different exceptions is when I was working at the Writers Guild. They were covered by a collective agreement, but then production companies would always have a rider of completely standard terms for anything that wasn't covered in the collective agreement. And a lot of that had to do with ancillary licenses to the work, because the collective agreement only addressed the copyright in the scripts that were being written themselves. But of course, now we know with movie and TV and all that, if you do something great, sometimes there's lunchboxes, sometimes there's sequels, there's prequels, there's action figures and whatnot. And I actually had a documentary maker who, actually went in and read his contracts and the writers that were put on there, and it was all pro forma language. Like, it was all, they put it in the same one regardless of what they were producing, who they were producing with, what was the topic of the production. And he noticed that one of the rights he was assigning or licensing, I guess in this case it was licensed because there was a certain period of time, licensing to the producers was that of literary adaptations, and most people wouldn't think of that or care about that. But he said to me, I have been researching this topic for 20 years of my life. This film is kind of, as a lot of documentaries are, like, represents the pinnacle of all my research. I do want to write a book about this topic. It's been my life's work. And I said, when your ability to negotiate and actually read your contracts come into play, because I'm pretty sure this production company probably has zero interest in writing and putting out a book on this topic. So it is definitely something that I think you should ask to strike out that very narrow exception for literary. If they want to make all the action figures in the world for this documentary that you're filming, if that's no problem to you, great. But if this is something you're going to do, I can pretty much guarantee they're probably not interested in it. They're just trying to cover as many bases as possible for them, and then have that conversation. And he did, and he got to keep it. And you know what? I don't know if he published his book, but I hope he did. So now that we know how you can give your copyright away, what does it require? What do you need to do in order to establish your copyright in something? So most importantly, and you see this word, and we talked about this word, is authorship. So as Kat said before, copyright is automatic upon creation. Having said that, there are different ways and different methods you can use to record that date. I think a lot of what we see in media and in news and whatnot around copyright rights is that someone has stolen someone said they had the idea first. And of course, the definitive way to prove that is to date your work in somehow. So you can do that by having your original work witnessed and dated, register your copyright. You can use proper marking for your copyright by using the copyright symbol, even on blogs and whatnot. You can throw that up there, and document details of any collaboration in respect to the work. So if you're working on something, collaborators, which happens quite often in this industry, to really outline your contributions and everyone's respective contributions. Again, using an example from when I worked at a guild, they had a script registration service where you could send them a copy of your script, and they were kind of like a third party that could confirm the receipt on a specific date, and you could pay a registration fee. A lot of people went the route of mailing themselves a copy of their script and keeping it unopened, so they would have that date stamp on the outside of the envelope with their script inside. Yeah, so I threw in a little thing, for example, of different types of authorships, probably for everyone on here. If you're working in a creative practice, your examples are pretty obvious. If anyone has any ideas and want to share the unique authorship ways.
The reality is much creation these days happens digitally. And fortunately, that means there's typically digital stamps and author information associated with the digital file, which does sort of help to manage the, presumptive created by as of whatever date. To the extent that you're sharing whatever the software is, if an author's name is pre-populated, that should be looked at from a digital stamp perspective. Registration is actually pretty cheap and cheerful, relatively speaking. If you go through a lawyer, it can be expensive, but if you do it on your own, it's $50 to register copyright in a single work in Canada. And it's proof of title. It avoids an infringer defense. And while perhaps not as relevant to this particular audience, it also shifts burdens in terms of proving originality. So the work is presumptively original. The other flag I'll make on authorship is joint authorship. And I don't know how to underscore enough that if you have a relationship with somebody and you are developing work together and you perceive yourselves as being co or joint authors of a particular work, to paper, doesn't have to be fancy, doesn't have to be a big legal document, to paper the terms, basically, like what's the deal? You're co-authors, you both need to agree on exploitation. Does one of you get to exploit? And as long as you account to the other, is permission required, et cetera, et cetera, et cetera. Like those are the biggest issues. The biggest issues are, one, do both of you need to agree before you license or do something with the work? Or can one of you do it as long as they agree to pay the other? Two, what's the split? Naturally, particularly at the front end, you may have one perception on who's going to contribute what to what and what's the split going to be. And then revisiting that openly as things start to transpire. One person carries the weight, but that doesn't necessarily, from a legal perspective, track readily, absent an agreement to the contrary, in terms of how exploitation will work. So working through, when you're collaborating, who owns how, what, where, and why, and who can do what is essential and quite important.
Yeah, absolutely. I echo that 100 times, especially because there can be such a long lag of time between the beginning of a relationship and the development of the work and the actual point where you are able to make money off your work. Things happen, relationships change, people may get work elsewhere. Sometimes a lot of compensation is tied to credit in a work. That's certainly that in screenwriting, playwriting, and whatnot. So have those conversations at the outset, because you don't know when the next pandemic's coming. You don't know, you may get a great job somewhere else as a collaborator. Things happen, and everyone goes in with the best of intentions, and everyone, doesn't want to talk to their lawyers at the beginning, and then life happens. And then, as a practicing lawyer, you get people at the worst times of their lives. But I happen to know that you'd rather get them at the beginning of a project when everything is happy and good. But like Kat said, it does not have to be complicated. Just have that conversation and put it down in writing.
You raised something that I think is also worth mentioning, is that authorship not only goes with ownership, but it goes with the right to be attributed or remain anonymous. Or some creators choose to use pen names, and being clear about that. You do have the right to remain anonymous or to use a pen name in association with your work, and to think about that at the front end as well is important. Do you want to be attributed? Do you want to be attributed in your real name? Do you want to be attributed using a pen name or a pseudonym? And to work through all that. You can actually register copyright in the name of a pseudonym. There's a mechanism to do that if you're aiming to keep your identity anonymized in some way.
Yes. And if you choose a pen name or to remain anonymous, that doesn't lessen your right to be able to earn the money from the work. All right. So let's talk about originality. I think that's sometimes the trickiest one when it comes to artistic creation. For the work to be original within the meaning of the Copyright Act, it must be more than a mere copy of another work. The expression of an idea must require the exercise of skill and judgment. So skill is use of one's knowledge, developed aptitude, or practiced ability in producing the work. Judgment is use of one's capacity for discernment or ability to form an opinion or evaluation by comparing different possible options in producing the work. It need not be creative in the sense of it being novel or unique. You don't have to invent a new wheel, but you do need to exercise a skill and judgment that requires intellectual effort. It just can't be copying. So all that is a lot of kind of legally language to break it down. So something that isn't original is recreating someone else's choreography exactly, but something original is putting together brand new choreography using commonly used movements. If anyone has any questions or have any examples that they want to contribute or put in here as questions or comments from the discipline that they're in, feel free to use the post-its down there. But I think you can probably all think for whatever disciplines you practice in where that line may be. And I'll again throw it to Kat to talk a little more in depth about this.
Canada likes to take its own approach when it comes to copyright. So our test for originality differs from the tests in other jurisdictions. In the US, they have a spark of creativity or a modicum of creativity test, which means that, it doesn't have to be super creative or super inventive or novel, but there does need to be some level of creativity in the works in order for it to be protected in the US. In the arts, that tends not to be an issue. Where it arises, or where I tend to see the issue arises, when you're dealing with copyright protection for sort of more commercial for like databases and for that type of stuff. Copyright protects not only works of art, but it protects, a whole series of other things, including software code and databases and forms and what have you. And it tends to be in other areas that we see sort of the originality challenge arise. In the UK, they have a lower standard. As long as you tried, as long as you put together a little bit of effort in the UK, you're copyright protection if you can demonstrate that it was the work was the result of labor. Sweat of the brow test is sometimes how that's referred to. And truthfully, we've had a little case law that's really explored what the skill and judgment test means. I do believe at this point, at least, is that you need a human author and you need some form of intellectual effort and you need people to make decisions and to apply that intellectual effort to the output. So to give sort of two examples, one would be, and there is a use case on this point, where a monkey took a picture and they tried to claim copyright in the picture, and it turns out monkeys aren't humans that can own copyright. And that was a US example, but it would track into Canada, in my view. Are you losing copyright as a result of that? And the jury's out. In my view, it depends on whether or not the AI is a tool that's being used to create, or whether or not really AI goes beyond that, is producing such that there's no human intellect that's going into the finished product.
We did have a question in the chat about what is your opinion on referencing someone else's copyright, like in a collage? If you're a visual artist and you're referencing someone else's work in your own works in the method of a collage, what are your thoughts about that?
So it's a clearance question. So then you have a layering, and there's a bit of a standoff in the sense that I think we'll get to fair dealing in a bit. Challenge in Canada is that we don't have fair dealing. You may have heard the term fair use, which is the term they use in the US. In the US, you can fairly use someone else's work provided your use is transformative. And in the arts, that tends to be the way things like using someone else's work in a collage gets expressed, that you're transforming what was being expressed in their work, and it ultimately has a different meaning. And there's a whole series of factors that get considered and weighed. In Canada, we don't. Fair dealing can be we don't have transformative fair use. Fair dealing must be for one of the stated purposes, which are research, private study, review, criticism, news reporting, parody, satire, and education. And so when you're dealing with collage in Canada, strictly speaking, there is an infringement if you're taking a substantial part. So typically you need permission. Unfortunately, we don't have very much case law on point here. And I do think, depending on the nature of what your collage is and how you're using it, the risk may be practically manageable if you're taking only a portion of someone's work, and you can argue it's an insubstantial taking. But the risk is material in the sense that strictly speaking, there's no, like pastiche, we don't have an exception for collage, we don't have an exception for all of these things. Really, permission should be sought before undertaking to incorporate someone else's work within your own.
And I think along with not wanting to expose yourself to legal issues or problems, it's also a question of collaboration and relationship preservation. And I think being respectful of other people's original work as well. Do you want that person to sue you? No, absolutely not. But also, do you want that person to be annoyed or upset or feel like their work has been used in a way? And again, this probably leads into moral rights as well, used in a way that they don't feel comfortable it being used or referenced in a new work.
And to round out, to give two examples, collage could, depending on what your collage is expressing, it could be used, or you could argue that you're sort of engaging in a parody or satire, using someone else's work for social commentary, using someone else's work to comment on their own work or a body of art, or that it's being used for comment and criticism, depending on the nature of how you're doing it. Typically for comment and criticism, though, it needs to be about the work itself. We've had one or two cases that have evolved a little bit further, but they're not a slam dunk. And then, as Jasmine said, the other big area is attribution. So even if you believe that you can fall into one of those exceptions, moral rights can be offended if you fail to attribute. So
Google is often your friend. So hopefully if you have a little bit of knowledge here and you kind of remember like, wait, they were talking about fair dealing, there are reputable resources that will kind of list those out as well. One other quick question before we move on is, do you have to register copyright for a work, or do you just put the C symbol on a digital image of the work? Copyright is automatic upon creation, so you don't have to register it, but it's a good idea. And we can talk about putting the digital image, the copyright on your digital work as well. We're going to talk about a little bit about digital rights management in that way. So you don't technically have to, but you can. As Kat was saying, it's pretty accessible. It's $50 per work. But again, the most important thing, if your ownership or your authorship of a work is challenged in the future is to be able to point directly to the time of creation, that it was your creation, and at what point that creation was put out into the world. Can seem pretty esoteric, especially when you get to something like legislation, trying to legislate what an expression of an idea is. So there's no copyright in an idea itself, but only in the expression of some. No copyright in ideas and information, and it is no infringement of copyright to adopt the ideas of another or to publish information derived from another, provided there is no copying of the language in which those ideas have previously embodied. Here is kind of like the easiest arts-based example. The idea of star-crossed lovers is not protected under copyright. Shakespeare did not invent that. But writing a story about star-crossed lovers or creating a performance about star-crossed lovers and its expression of the idea, that could be protected under copyright, as we have seen so many of our favorite rom-coms since the creation of Romeo and Juliet, before, after, and of course, Romeo and Juliet no longer is protected by copyright because Shakespeare has been definitely dead more than 50 or 70 years. So that's kind of how you distinguish between an idea itself and the expression idea. Of course, this is something that can be litigated, and I'm sure has.
I think sort of keeping in mind this line between expression and idea is quite important. I agree with what you said, Jasmine, in terms of ascertaining where that line is can be quite difficult, especially because you can actually infringe without any literal copying. So the legal term is colorable imitation, where there's no actual reproduction, there's no words or what have you, but you've basically taken the thrust of someone's work. And as a result of what you've done, you've infringed. And so it can be a bit difficult to sort of in practice draw that line. What is key, though, is that leaving aside the infringement analysis, from a protection perspective, the idea itself is not protected. What needs to happen is you need to express the idea in fixed form. So if you, absent a non-disclosure agreement, confidentiality agreement with someone, if you're brainstorming with them and you come up with an incredible idea for a new, art installation, a new treatment for a movie, whatever. You're just talking, and they go off and they run with it and they fix it and they do their own thing. Just the fact that you expressed the idea and you didn't fix it, even though you discussed it short of sort of confidentiality and non-disclosure undertakings, you have no rights. There are certain laws in certain jurisdictions that will step in to try to help. But strictly speaking, from a copyright perspective, that can be difficult, impossible generally, although every once in a while I get really creative with something to achieve.
But not only does it need to be an expression of an idea, but that expression needs to be fixated. So it needs to be expressed in some extent in material form, capable of identification, having more or less permanent endurance. For example, the work must be written or recorded. So for most works, fixation is automatic. You're writing a play, you're putting pen to paper, you're using your computer, you're putting paint to canvas, you're recording your choreography. But the fixation element, it does become a bit more challenging with something more fleeting like a performance, because something like dance is inherently ephemeral, different kind of performances in that way, live performance.
I think what we said earlier, or what I said earlier, is sort of, as you said, picked up here. I don't know that I'm happy to answer questions. I don't know that there's much more to say here other than if you don't put it into a fixed form.
That's a little more cut and dry than an expression of an idea, or is it an idea? Or Kat has put together these couple kind of copyright do's, and the next one you can probably get is don't. So they're pretty straightforward. But Kat, if you want to speak a bit more to this kind of best practice list that you've put together.
I think off the top, to state the obvious, create original content and original meaning, like not copying from others, but also something that sort of involves, from Canada, your skill and judgment, or from a US perspective, a bit of creativity. And in the arts, fortunately, that tends to be the case. Be very careful with taking inspiration. The line between colorable imitation, which I mentioned earlier, and inspiration can be quite thin, and it can also be often be a matter of opinion. If you are taking inspiration, don't look at one work, get a body of different parties' works that share similar themes. To the extent that you have sort of a mood board or something else that you're working from in order to reflect your points of inspiration, just be very careful with creating that kind of stuff. You might be creating evidence that will be used against you in the long run. Clear rights. Be very cautious with works in the public domain. The internet is not the public domain. In fact, most things that are available likely have some form of protection, short of works that were created, well over 150 years ago. Get a license, and it can be a paid or a free license if you're incorporating works of third parties. There are many systems available now that are copyleft, as some call them, Creative Commons being one. Use copyright notices, technological protection measures, and digital watermarks, like embed copyright notices not only visually in your work, but as in terms of metadata in works that are distributed online. And registering copyright, as we said at the outset, comes with certain benefits and presumptions. It's not required, though. In the US, you do need to register in order to litigate and to claim statutory damages. The registration must have been secured prior to any infringement. In Canada, you don't need a registration for anything. Putting a copyright notice, though, helps to demonstrate, and it can go to damages. It can go to not, practically you're probably all not be litigating anytime soon, hopefully, but to the extent that there was a notice and somebody removes it, for example, there's separate remedies that are available, technological, to the extent you're protecting copyright using logins or digital locks or encryption or the like, and somebody breaks it, there's a separate remedy available for that TPM violation, as well as the infringement that may flow from it. And for removing digital watermarks and digital watermarks and rights management information that's embedded. So I'd encourage using all of that. Supplement with terms of use where possible. So if you have a website and you're posting various works or versions of works on your website, not only do you want to rely on copyright, but having a contract claim is never bad. So terms of use for a website, for example, saying don't copy from this. Canadian law at least says that those things being posted is enough to make them enforceable on visitors of your website. So think that through. And give credit, cite the source when you do use third-party works for purposes that work. I will note that credit can be a catch-22 without permission. I have personally used moral rights in combination with privacy or personality rights to basically prevent something from being used. So if you don't credit me, you're violating my moral right. If you do credit me, you need permission to use my name and likeness. So those things can sort of go together. It's always prudent to be clear about what attribution another artist wants in association with their work, at least outside of sort of research, education research type uses or news reporting attribution type uses, criticism and the like.
Yeah, absolutely. In this day and age of reposting, people think it's okay to repost an original work as long as you credit the source. But
that's not.
And that's controversial here is if like Trumpers for life or reposting a cartoon you made or something, and you're completely morally opposed of, using your work, or, you hear, I guess, people using your song as an election song or something like that. Like these are the most like egregious examples I can think of off the top of my head. It's like, I don't agree with your politics, so don't use my song. You don't have the permission just because you're paying royalties or giving credit. Like there's still the moral.
Yeah, exactly. And actually those examples that you gave, there's real case laws, or there's real case law involving all of them. So Pepe the Frog, there's some US cases, and we won't get into them today, but they're worth looking into, involving how that artist's work was appropriated by Mr. Trump's campaign, or President Trump's campaign. And then there's a bunch of cases actually involving political uses of work, no permission being granted for political uses, including a Twisted Sister case that's going forward, I believe still in Australia. That's an interesting one to watch.
Yeah, and just a final note on, doing notices or supplementing with terms of use. If you can't hire a cat to help you out with those phrasings and stuff like that, there is, as long as you are going with a critical eye, there are resources online that can help you with wording and help you with very standard terms. Something is better than nothing, I say all the time. So if you're aware that these kind of tools can help strengthen proof of your ownership or whatnot, Google can absolutely be your friend in these cases. Just do it as you do most things in life when you Google them, with the critical eye. We know a lot of people aren't just content creators, but content users. So what shouldn't you do, especially if you're using someone else's work?
So I think in the internet age, especially, copying and pasting is creating a lot of issues. A lot of people will just reproduce third-party works because it's easy to do, truthfully. Anyways, so don't be what I call right-click happy, where you reproduce third-party works. Don't tamper with or disable digital locks or encryption, digital locks being technological measures that people use to prevent either copying or access to their works. Don't remove rights management information. If you see a watermark on a third-party work, don't leave it there, or do leave it there, don't remove it. And don't assume crediting an author is enough. Don't assume that you can just take someone else's work and provided you attribute to them, you're out of hot water. That doesn't necessarily get where we need to give.
We do want to do some distinction between being right click happy because you're sending a funny meme to your friend over text, or a funny cartoon over text, and doing it, incorporating a new work or passing it off as your own work, or sharing it in a way which would financially benefit yourself. Just to bring up the difference between private use and public use, and the whole concept, and reframing it and understanding that the frame in all this is, are you benefiting from someone else's work? So we've established copyright. You haven't stolen anyone's work. Your work is original. It's fixated. Now what? I want to make money off of it. What do we do? Usually we enter into a contract. So there's different types of contracts. Either, we've spoken to this before, it's a collaboration between artists. Either you're bringing your individual work to each other and collaborating on that, or creating a new work. You can commission or license work by producers or presenters. A typical example is a playwright can be commissioned to write a new work for a theater, or can have a work that's already completed and that can be presented by a theater as is. And of course, in this sector, there are lots of collective agreements which will cover the performer or artist, writer, if they're a member of that union, and will address how copyright is used in there. Uniquely, the Writers Guild of Canada is the only writers union that doesn't allow for the assignment of a copyright in a work. They only operate on licenses, and that's unique across the globe. In the US and the UK, when a producer will produce your work, the baseline is that you are assigning that copyright entirely. Here in Canada, it's a system of licenses to produce it and then to distribute it. And I think, as I mentioned before, but a lot of that comes with ancillary rights. So your collective agreement cover off the intellectual property, but it doesn't mean it's covering off every aspect of it. So that's just something to keep in mind if you are part of a union or if you're working with artists. So I put a little note because I'm referencing my other workshops here. I talk about how if you're entering into a private contract with another person or an organization, for the most part, any terms of those contracts are negotiable, the exception being when there's legislation that regulate, whether it's labor laws or in this case, copyright law. So copyright law is an example of how legislation does have to be followed in private contracts. In the sense that, said, you can't assign your moral rights to someone else. A copyright is a right that you need to discuss and talk about, and you have to make sure that you actually have that right before you give it away to someone else or assign it or license it to someone else. A few good reminders that I like to tell artists when I work with them is that intellectual is still property. As artists, as creators, your work is easily shareable. A lot of times people want you to say that, oh, let me use this, let me show this, let me work with you, you'll get this great exposure. As I know, good exposure doesn't pay the rent. You wouldn't expect someone to give you your boat for free so you can use it. So don't think of your work as something that, and I don't expect anyone who is on the session will hopefully think about that way, but it's a long history of artists, because of the nature of the power balance and working with a producer or a presenter or someone who can easily undervalue their work for things like exposure or the partnership. Again, a little plug, it's why negotiation skills are important, because compensation doesn't always have to be monetary. If there's a power imbalance, that means that the person you're working with, whether it's a producer, whether it's a presenter, an exhibitor, an organization, often has other things they can offer you other than pure financial compensation. And to keep that in mind, again, we've touched on it's not all or nothing. You can license your work non-exclusively. As I mentioned in my example, the documentary maker wanting to reserve their literary rights. There are a bunch of rights that can come out of your creation, and you don't need to assign it to someone forever. That's not the only option. You can license it to someone for a short amount of time. You can license to multiple people for a short amount of time. You can license one aspect for a short amount of time or a long amount of time. And really, and we're stressing this the whole way through, is discuss things before a collaboration begins. Set out your ground rules in advance, put it in writing. you never know the nature. Lawyers exist because people go in with the best of intentions, and for whatever reason that relationship break down. It's not always intentional, it's not always malicious, it's not always because of bad actions between either party. Sometimes life just happens, and the best that you can hammer things out, even if it's your oldest collaborator, your best friend, someone you trust implicitly, I think it just benefits everyone in the long run.
Yeah, and I guess the one thing that jumped out when you were speaking was on the moral rights. So one of the areas where I do see slip-ups happen regularly is there will be a blanket waiver of moral rights without reference to attribution, and artists will sign it, presuming that they're just, I don't know, waiving something. That moral rights sounds nondescript, but when you do grant that waiver, you're giving away your right to be attributed, and sometimes that can be built back in from an attribution perspective. But from the artist's perspective, when you see a waiver of moral rights, typically I would strike that, and I would aim to achieve clarity on what rights you want. So if you want to be attributed, be particular about it and confirm that the attribution will then, satisfy your moral rights. If you're prepared to waive integrity, so the right of integrity is the right to maintain sort of the integrity of the work itself, which isn't particularly well rounded out. It's also the right to prevent your work from being associated with a cause or institution that you don't love. So depending on the nature of what rights you're granting, you may be okay with, this work can be associated with, I don't know, in particular, if you're developing something for a brand, it can be used in promotional stuff and associate therewith. And there may be circumstances where that's not okay. There may be circumstances where you're okay with your work being incorporated into someone else's work, or you're okay with the integrity piece, the integrity of the work itself, but you're not okay with the cause or institution. So just be very mindful about moral rights waivers. They sound really benign, or they can sound really benign or obtuse. What you're waiving there is actually pretty material.
I think people have a tendency to forget about moral rights because of the focus on financial rights. But I do believe as an artist, as a creator, your moral rights are equally as important as your financial rights, because, like the French did 300 years ago, recognize that the statute of the work of genius, that it is something the creator that has put forward in this world through their effort, through their skill and expertise. And so you implicitly, have that right to decide what happens with it. That's, I think, equally as important as having the right to earn a living off of it. So yeah, thank you. Thank you for stressing that.
The areas that I find are trip up areas are the ones that I mentioned earlier in terms of assignment versus license, and not sort of slicing and dicing the rights as you wish, exclusive, sole, non-exclusive. Those are big red flags. The other area where there can be trip ups are representations and warranties and indemnities. So representations and warranties are where typically you're saying, I confirm that this is original and it's not infringing, and the rights I'm granting to you won't infringe any third-party rights. When I'm on for the artist, try to temper that, because practically speaking, you can't control accusations that third parties are going to make against you. And you may be confident that the work is original to you, that you authored it, no one else was involved, but you're giving a pretty blanket representation. And indemnity is the big legal word that a lot of people are confused by, but basically it means that you are agreeing to defend and hold harmless. Hold harmless meaning you will pay in the event that a claim is advanced against a third party. So be very careful and think through representations and warranties as well as indemnities. In many contexts, the indemnity, you may be assuming a lot of risk associated with, whatever it is that you're granting rights to. On the representation and warranty side, a really easy little trick is, to the best of my knowledge and belief, I represent and warrant. So if you add in that language, that at least from a 30,000 foot level gives you some wiggle room to say, at the time I did it, I didn't know that. All right. For indemnities, I would usually try to restrict it so that it's, any successful claim. I will indemnify you to the extent that I breach my representations and warranties with respect to any successful claim, that you're not on the hook for defending, claims that are advanced. And you want to make sure that there's a carve out for anything that's done on part of the person you're giving the indemnity to. This is a pretty nuanced area of law, but keep that in mind. Other big issue is termination and how termination works. So be very careful to make sure that you have an out, that if this isn't just a contract that will go on and on and on, but that if certain things happen, you have the right to terminate. Deep dive, you could do a whole session on this, just this slide, truthfully, but this is where things readily get tripped up. And I guess big picture is don't blindly sign an agreement that you've been handed.
in my teachings, my completely made up way of how to vet a contract is really based on look at who, what, where, when, and how, either how to vet a contract or how to put together your own contract and make sure that those questions are answered. At the most basic, a contract is offer, acceptance, and consideration. But in real life, you need to answer those questions. Someone asked a question about templates. That's a tricky question. In a perfect world, there's templates for everyone to access that are free and that are available. And again, it's hard to have a one type fits all given the breadth and the nature of different types of creation, of where it can go and what you're doing with it. Having said that, there are quite a few resources, especially through associations that may represent that type of work. Whether it's something like PACT for theater companies or CARFAC for visual artists, PGC for playwrights. Even if that organization is a union organization, you may not be a union member, there may be some resources that they can help you out with. Of course, there are also, and we'll say this again, those clinics, those free legal clinics across the country that you can ask to. But I also encourage people to, think about lists like this and try to educate yourself on a bit of contracts, because you empower yourself to make your own templates, what works for you. Again, something is better than nothing. It doesn't have to be perfect, as long as, you're seeking out to try and protect your rights and do something that works for you. Chances are you going to end up in court of it? Like, let's be honest, in this particular sector, probably not. I don't want to give do whatever you want and there's not going to be any consequences. That's not what I'm saying, but I'm saying realistically in this sector, the most important thing is having something in writing. So to be aware of these things that you need to be thinking about when it comes to your IP, being able to empower and educate yourself about what makes a decent contract and what you should be thinking of, I think are two really important steps to managing your work.
Presuming there is money that's flowing to you, aim for a set-off rate, or money that you're paying, aim for a set-off rate. So for example, if you're paying somebody for some work, and they have to, do certain things, give yourself the right to set off money that is owed to you against what you owe to them. This can arise later, and this may be a very specific thing, but it often gets missed, and it can be helpful in the long run. And two is think very carefully through lump sum payment, advances, royalties, and ensure that you have audit rights if presuming the money's flowing your way. And little practical things to ensure that you're thinking through when you're looking at a contract.
So I just wanted to highlight, and I think we've talked about this quite a bit through what we said so far, about this digital age and how that changes things, especially coming out of the pandemic, where a lot of artists did end up having to move from live performance to digital performance. I don't think that's going away anytime soon. So we just wanted to touch really quickly on considerations going digital. And I don't necessarily mean things that were meant for digital creation outset, but also kind of sharing your work digitally that is normally live performance. So a couple tips, streaming through YouTube or Facebook Live. YouTube especially, has a system in place to compensate for views, and it's, they're pretty good, I think. And Kat, you can comment this more on having a mechanism that if you feel like your work is being reproduced without your permission, to at least follow up and to deal with that rather than Zoom, because anyone can record a Zoom. Consider that if you want to put the performance online, to ask for a donation or a small fee. Again, this goes back to my point about wanting to put your art in the world, but also remembering that it is property, and you do deserve compensation for all your hard work. And then once it's online, it can be something that be broadcasters, and once something is broadcast, and again, we could do a whole session on this, which gives rise to a whole other set of rights that you would need to pay if, you're working with unionized actors, choreographers, audience members, musicians. Just something to keep in mind. Kat brought up a really good point when we were discussing this about the importance of digital rights management, which you have touched on, but if there's any, like the watermark and the embedding things in the metadata, but if there's anything else you want to speak to specifically regarding digital rights management?
No, I think just use it as sort of the punchline. To the extent that you can, use copyright notices, digital watermarks, and embed information, do.
So infringement. So again, I think we've covered a lot of this thing. It's like what happens when you find your work being used in a way, or someone else is profiting off your work, or using in a way that offends your moral rights, that violates your moral rights. This really goes into what the courts are looking for to prove infringement. And the little note that Kat made me aware of about the way that the courts approach this is quantitative and not qualitative. Infringement doesn't necessarily mean straight copying to the courts. I'm sure there's a whole body of work again that you can discuss. So I wanted to leave this out there so people can have this as a resource to see what the courts mention. But I think the other thing we already touched on is the user rights is the fair dealing. And again, to understand that not all uses are infringement. I think it's the point that I was trying to make here by putting fair dealing into the infringement portion of our talk.
This is user rights. So in Canada, the Canadian Supreme Court's taken the position that there's copyrights and then there's user rights, and they should be balanced. The mandate of copyright is to create a very rich common area where people create and make their works available. And as a result, user rights should be given sort of equal weight and balanced copyright. That said, relying on user rights is very dicey from a Canadian perspective. As I said at the beginning, there's very specific grounds for user rights. In the US, it's a little bit more fulsome. And then the use not only needs to meet one of those grounds, but it has to be fair. And there's a series of factors that will be considered with respect to fairness, or whether or not a particular use is fair. On the parody side, which maybe is one of the more relevant areas to artists or the creative community, parody or satire, we've had two cases so far, both of which suggest that anything that's overly critical will not qualify as fair. It may qualify as the use may qualify as parody or satire, but if it's overly pointed, it may not be considered fair. Yeah, we could spend a lot of time on this.
But we just want to make you aware, that there are exceptions. Not every use is an infringement. These exceptions are carved out, to be aware of that as both a creator and as someone who is potentially could be using someone else's work for one of these exceptions. All right, so here we go. Reality. What can you do? So some tips: contact the person or organization who's infringing and notify them of the infringement and ask them to take it down or stop the infringing activity. I think the easiest example is digital in this case, but sometimes, especially in the case of visual artists that are shown in galleries and whatnot, usually they will do some research on provenance and make sure that they have the right to display the artwork. But I personally have heard stories from artists where they have seen their work or their work incorporated in other people's works that they did not approve of, and whether or not the actual organization was aware of that is possibly a conversation to start with after addressing the artists themselves. If they're not doing anything to rectify the situation, negotiate payment. Like, again, this is a question of your financial or moral rights being infringed, meaning that you are not able to benefit from the work that you created, or it may be used in a way that you do not approve of. And online, talk to the platform. Again, that's the thing that you can do. It's an issue that happens a lot. I kind of put in taken public ... in this area of social media and stuff like that. We see a lot of things, where people can't, if you're addressing the person who has potentially infringed your own work, if you talk about it publicly, especially within, it's a small world here in Canada. I don't think anyone wants to be known for violating another artist's rights. Be strategic about it. Like, it's a kind of a last resort, but it's a tool we see people use every day in many different circumstances. They're not getting a resolution privately, which they think is fair.
Well, one of the flags I'll make just on that is you have to be careful with defamation type claims when you're alleging someone infringed your work.
Thank you.
So
absolutely.
Be very mindful of making those sorts of accusations, particularly against third parties. And you can get a ways by just picking up a phone and trying to address something directly with whomever's on the other side. That doesn't always work, but I'm always surprised at when I am sort of engaged in a new matter and I'm like, well, what's happened so far? Like, have you spoken with the person you're so upset with that you collaborated with about this? So to the extent that you can self-help, do self-help.
And again, understanding there's a lot of emotion going around being able to pick up that phone and understanding why that's a hard hill to go across. I love plugging myself. And again, this is another reason why when I've designed these courses, I'm doing one on difficult conversations that really recognizes the difficulty in having those conversations and the intimidating nature, especially if there's a perceived or inherent power imbalance. But there's lots of tools that you can look at, whether it's mindfulness, whether it's preparation, whether it's research, to help those conversations be more manageable. Because, a lot of reason people hire lawyers is it's worth the money to not have to have that conversation personally, because it's such an emotional thing to deal with. Having, been there myself too, that paying someone to be your advocate is a great resource to have, but not one that everyone can access. So there are lots of tools out there to help you prepare for that kind of conversation, both kind of research-wise and mentally and emotionally. And again, legal resources. So the National Network of Legal Clinics has set itself up trying to link all the legal clinics across the country. You can Google them. They'll give links to contacts for everything there. Like I said, Kat is involved with ALAS here. I've worked with them time to time. They're amazing. CARFAC for our CARFAC Ontario members is a visual artist legal clinic where they partner with a law firm here to give to have access for their members. So I feel like the barriers are being lowered. I think there's a lot of push to provide either free or affordable advice to artists, and a recognition that it's a healthy thing for the sector to provide that to them. If you are in the market for a lawyer, obviously Kat is a great resource, but the best way often is through referrals. Chances are, if you work in this industry, you know people who have had to engage a lawyer before. Ask your friends, ask your family, colleagues, association that you may be a member of that represents the type of work that you do. But just make sure that they practice in the correct area. Don't ask your board member who specializes in tax law, maybe to help you with a moral rights issue. Ask them if they know anyone who may be able to who specializes in that area of work. I think as lawyers, a lot of times, we get our family members asking us how to get out of traffic tickets. And, we know a lot, we can figure out a lot, but we don't know everything. So it's really the best use of your time and your money, if you are going to engage a lawyer, to make sure that you're doing so with someone who specializes in the issue that you're looking at. And the violation is online. There are systems built in, especially for the larger platforms, that can help you get it taken down, or the infringement. But the caveat Kat pointed out to me was that you have to make sure you have clear ownership proof. And again, that goes back to whether you're registering, your digital rights management, figuring out a way to prove that you are in fact the creator of the content. And so we'll leave you with this, but I'll leave this up, my one sports metaphor for, all my artist contracts and negotiation workshop is the best offense is a good defense, which is prepare beforehand, be mindful of all these issues. Don't let them consume you to the point that they impact your creativity. Just my little list of things just to keep in mind as you go forward, as you manage the business side of your work.
Thank you for inviting me. Thank you, Jasmine and Jag, for putting this together. I think from my view, this was a great session, and I think you're putting information out there that hopefully will be used. So thank you both very much. And thank you all for joining us.
Yes, thank you so much, Kat, for bringing in your expertise and being able to take it down from my 30,000 feet to at least 10,000 feet, I think is helpful to a lot of people who attended. So having said that, I'm going to thank you for legal resources, myself. We all exist in this world to help you all out. Thank you.